VPN or some sort of access within their protocols. If they don't agree to that, then they agree to indemnify me and hold me not responsible, and I'll use my own systems. And I think that goes into...
Yeah, basically the same system.
Yeah, it's good for everybody.
Yeah, I think so. And it makes sure that your outside counsel is like giving you advice and sharing things with you in the manner in which you do your everyday business. So it's not just a security benefit, it's also just like a practical ease of business doing, to like set them up with a 23andMe account, let them, you know, run in the cloud the same way we do.
Yeah, and so those are fantastic points, and I hope people are hearing them because they're really, really important things to take away. And I think they go directly to the background duties, which is how I'll sort of wrap this up. They really, I view those, a lot of what goes on in the background duties personally about, you know, setting expectations with your client and yourself, right? And forming an understanding of what the, you know, what the ground rules are going to be, right? What do we view together as reasonable in this scenario? And that as I think all the panelists just highlighted is really sort of a negotiation, a diligence process, that needs to be had up front, because otherwise you're going to have a problem later, and you're going to have an utter lack of clarity. And it's going to probably not end well for either side. So, you know, it goes back to the main point I wanted to make at the front, which is invest in this stuff early, because we all probably will be affected at some point in some sort of data security, data breach, whether it happens in our personal lives, in our practices, to our clients, whatever. But if you've I guarantee you it'll be probably a lot less bad if you have made some of these investments on the front end. And then there are some that may occur that, you know, are totally out of your control, and that's the world we're living in. But the stuff you can't control is that front end investment. So we hope we've given you some ideas on that. And here's kind of our leaving statement here, but Josh, did you want to say something?
Yeah, just on that topic, if you are doing the IT yourself, if you're a solo shop or you're like in that group, make sure at the very least that your updates are up to date. I can't think of a less easy way to try to keep things in control, because when those updates, they're security updates. That's what they're doing. They're fighting constant exploits that they're fighting. I'm imagining that if I were audited by the California Bar or somebody, and because of a breach or something, and they found out that I hadn't updated my security updates since, like, you know, 2015, that might be really bad. Sorry.
And that's actually a change in the mantra. If you talk to IT guys, historically, they would say, you know, we want to put them in a test environment, we want to make sure nothing breaks. And law firms have a lot of complicated and archaic software, and so that's kind of a valid thing to do. But you have to be, I start with be aware of your personal attack surface, and make sure you're comfortable with that. So the things that are within your control, I agree, you should patch them before you get the alert, because there are ways to find out the minute Apple releases a patch, even though you're not slated to get the automated alert, because they stage that, right? So update, or any of the Microsoft, any of them. And more often than not, I mean, I know Spectre Meltdown, in the Intel patch, there's been some problems with that, but more often than not, you're not going to introduce a secondary problem by patching immediately. And of course, the other mantra, back up before you do it so you can roll back if you have to, right? So deal with your personal attack surface first and have a comfort level with that, then deal with your personal professional, and then understand what your firm of whatever size or company is doing at the last level to minimize their attack surface.
Great. So I think everybody can read this last slide, and I know we're running out of time. Do we want to do questions, even if there's just one or two? Yep. So floor is open for anybody who has them.
You mentioned, looking at contracts with your vendors, looking to make sure they have good terms. I'm curious if in looking at these contracts, they're often like a choice of law provision. Do cybersecurity and privacy issues inform what you want in the choice of law provision?
Yeah, I'll take a stat. That's kind of a secondary concern for me, and it really depends on whether you're talking about a U.S. jurisdiction or someplace else, and then what aspects of security and privacy that's going to impact relative to whatever services you're getting, because of the problem of different standards as to what PII might be, or different standards as to what encryption and how encryption phases into or factors into the data stream, how sophisticated the various jurisdictions are, and how they tend to react. But I see that more as a secondary concern.
For me, jurisdiction is based on my client's need, and mostly they're California-based venture capitalists or California-based technologists, and that means they're one of three jurisdictions, and the security and privacy issues don't really come up on that. It's Delaware, Nevada, or California.
No, yeah, I agree with that.
Yeah, I'd say that it's, in my view, just sort of thinking about it on the spot here, it would be like a secondary issue, as Bill said. And for me, at the end of the day, really, it's about whether the contract's going to be enforced or not and what the contract says. That's what I'm more concerned about. So in this area, I want to know that I'm getting the protections in the agreement that I'm looking for based on the diligence that I've done on that particular vendor, and based on my own awareness of that, what their technological capabilities in this area may or may not be. Sometimes that's really hard to find out, and you just have to kind of wing it a prayer and go. But as long as it's got one of those jurisdictions that were named, New York, Delaware, California, those are kind of, and then as long as you're following the rules on enforceability and you're happy with what the contract actually says, I would be less concerned sort of about the choice of law provision itself. I mean, if you're collecting, or sharing loads of EU personal data, at the end of the day, GDPR is going to be applied to you anyway, and the regulators are going to have their own opinion, and then we'll see what happens to you then. But the contract itself may not be that important at the end of the day in that type of situation. So,
what's the difference between the enterprise Google Docs versus consumer Google Docs?
There's a number of choices you can make on how to implement your Google Cloud and Google Storage that happen on a much more sophisticated and tailorable level at the enterprise. So we can choose account access and revocation, how long storage happens, if information is two-factored, and there's just a variety of things that Google, as a paying customer, offers you the ability to customize and control, whereas as an individual and getting the free product, you don't have any of that opportunity to customize.
They have different privacy policies and terms and conditions too.
At a simple level, consumer cloud, you are the product. It's free, you're the product, right? And any consumer cloud, whether it's Google Docs or any consumer cloud, you're the product, right? And as you step into enterprise cloud, you're paying for things, you can negotiate things, and you have control or more control over the terms and conditions of the relationship.
Yeah, it's always a really good basic advice I give to the company is even if it's $5 a year or the free version, pick the paid version. There's a reason you're paying, and it's likely going to give you a lot on the back end in terms of your protection and liability.
And your contractual stance is a lot stronger too, because you're giving them money for a service, and if they don't provide that service, then you have a recourse.
Another example of that in the Office 365 environment, if you're an E1, you're not really getting full access to the Security and Compliance Center. You're not getting access to the tools that Adam might need to figure out, whether that cloud service was an attack vector. If you're an E3 or above, you're going to get that. And, there's a different cost associated with that, and so IT with stiff budgets might put you on an E1 license, and you get a lot of great collaborative features and functionality, but if something bad happens, you're stuck. If you're an E5, you're in a great shape, but you're paying for that.
And on that scary note,
We have one more question in the back, but I know.
Can we take? I think we're good. If you have a question, we'll be up here. You can
Okay.
ask it to us directly. But thank you guys very much.